Alex here with part 215 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go straight into my mindset, and I was livid, beyond pissed off. I've already done a video on discretion that explains how these judges, they exercise their discretion in a way that the bias and the incompetence bleeds through. And this is not an example of discretion. This is an example of a statute that told the judge exactly what she was supposed to do. It made it crystal clear that it was mandatory. I think the language they used was peremptory, mandatory, and there was some other word. And even when there is no discretion, they still can't follow the rules. One of the biggest things about going through the My Docket series is there are a few times when I think I am really harsh on the judges. I'll say something like, they have thick skulls, I think, for example. And sometimes I think about editing that out. I'm like, oh, I should go back and edit that out. That sounds bad. But then there's moments like this where I'm like, they do have thick skulls. They are stubborn. And I just have to remind myself, I'm not trying to bash the judges for the sake of bashing them. I'm not trying to exaggerate how I feel. My statements are accurate. That is exactly how I feel they are. When you see these kinds of rulings come down, there are probably worse words other people would use to describe them. And so I'm glad I didn't go back and edit those kinds of statements out, because that's the reality of the situation. I really spent a lot of time talking about my outrage when it came to the court's handling of this. And so I'm not going to go too much into the outrage portion. I think what I meant to say just now was that I discussed it during the earlier part of the video on the motion itself, on the motion that I filed. I will mention one more thing. I do want to state, because some viewers brought it to my attention, and what the viewer stated was maybe she just felt bad that since she screwed up, your ex shouldn't have to pay for her screw up. That actually could be true. It is possible that the judge was like, okay, well, I screwed up. I shouldn't have given her attorney fees. And so since it's my fault, I'm going to deny his request for costs. Okay, number one, that's a meta ruling. Please watch my video on the topic meta rulings, because that's a ruling that's not based on the law. That's just on some personal internal feeling that the judge just invented. Number two, I don't feel bad for the judge or my ex. The judge was told to commit that mistake by my ex's attorney. So that's as much my ex's fault as the judge's fault. In my opinion, my ex duped the judge into breaking the law, and so my ex should have to suffer the consequences, which is to not only lose the award that she should never have had in the first place, but she should also have to pay all of the costs that I had to pay to bring the appeal to fix the mistake that she tricked the judge into committing. Now that doesn't go for this mistake, because this mistake that the judge is making right now, my ex is going to also have to pay for. Only this time there's no, blame for my ex, because my ex doesn't file an opposition to that motion. This is an unopposed motion that the judge rules against me on. So this mistake really isn't my ex's fault, because my ex didn't file an opposition. So if there was any sort of situation where the judge should feel like it's her fault, it's this time. And so I really wish that the Supreme Court and the Court of Appeals would force the judge to pay when they deny an unopposed motion. Because if something isn't opposed, that means the other party doesn't mind if it's granted. So if the judge is going to step in there and white knight for the other party and protect them, when the other party didn't ask to be protected, then if you file an appeal and you win the appeal, I don't think it's fair for the other party to have to pay for that judge's screw up. The judge is the one that screwed up. The other party didn't file an opposition, so the judge should have to pay for all the, the costs and such. I think that would probably get a lot of these judges to stop doing this knuckleheaded stuff. I think that would go a long way too to helping people not be so I think there's a phrase that I'm looking for here. It wouldn't undermine the public's confidence in the judiciary, because think about how my ex would feel. She would be like, what's going on here? Why is the judge denying this thing that I didn't even file anything on? I really don't care. And why do I have to pay for him to appeal something that I didn't even fight? I mean, think about how you would feel if you decided to not fight something in court and the judge was like, oh, no, that's not fair. I'm going to protect you. And then you're like, okay, well, I guess that's fine. Ouch, now I have to pay for this appeal? Like, how would you feel about that? That's really damaging to anybody's sense of fairness, to have to pay all of the costs on appeal for something that they really didn't care to defend anyway. It's like, think about that a little bit. So there's a lot of problems when you get into meta rulings. They really just lead judges down the wrong path. And of course, I think I've mentioned this to you guys before. When you file an appeal on something that's not opposed, the other person doesn't get to participate in the briefing, which just puts a big fat target right on the back of the judge, because that means the Supreme Court's going to look at an opening brief and they're not going to even ask the other party to participate in the appeal. So that's just setting the judge up to be overturned on appeal. It puts the judge in such a vulnerable position. Anyway, I think that's all I have to say about all of this. We're going to go through the excruciating process step by step throughout the My Docket series. And so all that being said, let's go ahead and take a look at what the judge has filed. Here we have the judge's order after reversal and remand, order denying a motion for costs and for return of cost bonds, and order... Wait, what? Order for return of appeal bond? What? Okay, so the judge doesn't know that that's the same thing. The cost bond and the appeal bond are the same thing. So the judge is saying she's denying the request to return a cost bond and she's granting the request to return the appeal bond. It's the same thing. She just gave it a different name. So she probably just either copy pasted this or put it together really sloppily without paying any attention. Going into the standard introductory paragraph, she is recognizing that the Court of Appeals overturned her decision awarding attorney fees to my ex. She's recognizing that I filed a motion for costs and return of cost bonds, and she is ordering as follows. Number one, based on the Court of Appeals' decision reversing her decision, she is vacating her January 26, 2015 order granting attorney fees, and as such, the subsequent award of $1,715.64 in attorney fees and costs to my ex is vacated. Then she is going into my motion for costs and return of cost bonds. She is recognizing that I'm requesting costs in the amount of $250 associated with my appeal, and that I'm requesting the court return my $500 bond to me. Costs on appeal to the Nevada Court of Appeals shall be in the discretion of the court when a judgment is modified. That's the statute 18.060 sub 2. In the event no order is made by the Court of Appeals relative to costs, the district court shall award costs to the party obtained. What? Where's she getting that from? Wait, she's just inventing the law now. In construing the statute, we have held that its mandatory requirement of the awarding of costs is clear, emphatic, and peremptory. Okay, that's weird. So she is quoting this case, which states, in construing the statute, we have held that it's mandatory, blah, blah, blah. But up here, she's saying that only when no order is made relative to costs, then she can award costs? That's a contradiction. So again, guys, I don't think she read what she signed. Somebody else probably prepared this and she probably signed it without reading it. Next, we have the Nevada Court of Appeals reversed an award of attorney fees. The Court of Appeals remanded the matter with instructions to make more specific findings. No, it didn't. So she really, she just went from making an honest mistake to malevolent. So to me, this is her deliberately saying things that aren't true. If you guys look at the order of reversal and remand, there is no instructions there to make specific findings. This court chose to vacate the award of attorney fees. The Court of Appeal did not modify the judgment. Thus, my motion for costs wow, I just lost all my respect for her. Wow, I thought she made I don't know what to think, guys. I mean, I knew that this was a disaster, but now that I'm reading it, it just sounds like a bunch of globbity-glook. It's like a word salad. She's making statements that are contradictory within the same paragraph. Anyway, there's no need to spend a lot of time trying to crawl into her mind. because I can't make any sense of any of this. What matters is the Court of Appeals is going to thump her again, and they will overturn this decision again. So she's going to go from making my ex have to pay $250 in costs to making my ex have to pay $500 in costs to pay for her mistake. This is what I was talking about earlier with it's really not fair to force my ex to pay for something like this. Like this is egregious judicial misconduct. It's extreme incompetence. I mean, it's like a 2-page order, and the appeal, wait till you see it, the appeal is like a 3-page brief, and the Court of Appeals overturns it lightning fast. It takes them like 3 months, which to normal people, they're not going to think that's lightning fast. Trust me. For an appeal, that's fast. She gives me back the $500 cost bond. That's nice. The cost bond is my money anyway, so she's giving me back my own money. We have the certificate of electronic service here. This is indicating that she has sent this to me electronically and mailed this to my ex. Next document. Notice of appeal. It didn't take me long. I filed the notice of appeal the same day, literally within hours. So she files her order denying, and I hit her right away within a couple of hours with a notice of appeal. And I'm indicating that I'm only challenging the portion of the order denying costs on appeal. Rule 5 certificate of service indicating this document was mailed to my ex. Case appeal statement. Here we go again. You guys have seen case appeal statements, and this is just another case appeal statement. If you have any questions about these, just let me know down in the description below. You've seen one, you've seen them all, really. You just go down a list of criteria and you put in, details like who's the petitioner, who's the respondent, who's the judge. It's really not a legal document in the sense that you're putting in points and authorities and statutes. You just go through the motions and stuff like that. I wanted to mention also that I probably shouldn't have prepared this in the first place because in Nevada, the rules of appellate procedure expect the clerk of the court to do the case appeal statement for you if you don't have an attorney. And so I don't have an attorney. I'm representing myself. And so the rules of the Supreme Court, specifically the rules of appellate procedure, are that the clerk of the district court is supposed to prepare this document for me. And if I could go back in time, I wouldn't prepare it. We have a certificate of service here indicating this document was mailed to my ex. We have a case appeal statement. Again, this is the one that's prepared by the clerk, consistent with the rules of appellate procedure. And I do want to mention something, even though the clerk is supposed to prepare them and not you, it's not like they get it right every time. One of the things that they seem to get wrong a lot is the portion on family law. Let me track it down here. Where is that? Yeah, see right here. This case does involve child custody or visitation. They're saying that, but it really doesn't. The appeal is just over money. There's no child custody issues in this appeal. I think that they just look at the case number and they see the FV, and so they just put this down as child custody without looking into any of the details. So, I mean, it's nice that the clerk of the district court does this for you, but they don't always get it right. In any event, it doesn't matter. The Supreme Court figures it out. Certificate of clerk and transmittal, they are indicating that they have transmitted to the, what do we have here? Supreme Court, the notice of appeal. We have the corrected case appeal statement. It looks like the clerk of the court corrected something in here. I'm not going to really dig through this and find out what it was. If you would like to, you guys can go ahead and take a look at it. But let me know down in the comments below if it jumps out at you. But I highly doubt that the correction is something that's really material. We have the certificate of clerk and transmittal. We have, what is this? Transmitting. The corrected case appeal statement. Okay. Notice of entry of order. This is me filing the notice of entry of order on the order of reversal and remand and order denying. I don't really know if I had to do this, guys. I talk about the notice of entry of order in a video dedicated on the topic. It's called Notice of Entry of Order, and I talk about how it triggers the timelines for filing an appeal. I think what I was worried about was that it might cause issues in the Supreme Court that it wasn't filed. Of course, my ex isn't going to file it. She's not participating in the case anymore. I think that just to play safe, I filed the notice of entry of order, against myself, I guess, in a way you could say. I just didn't want to deal with any possible hangups in the Supreme Court, so I filed the notice of entry of order. If you want to learn more about why, please watch my video on the topic, notice of entry of order. We have the certificate of service indicating this document was mailed to my ex. Next, we have the order directing transmission of the record. The Supreme Court of Nevada, specifically Justice Cherry, has directed the district court clerk to send everything up to the Supreme Court. They have some concerns. We have the certificate of clerk and transmittal record on appeal, and this is the clerk of the district court indicating that she has complied with Justice Michael Cherry's order and that she has transmitted the entire record on appeal to the Supreme Court of Nevada. Lastly, we have the notice of change of address. This is me just indicating I've moved. This is a very important document. If you want to learn more about the notice of change of address, please watch my video on the topic, notice of change of address. So I filed a motion for costs on appeal. The district court judge disposed of that motion by denying it. Going into the aftermath, I filed, it looks like 1, 2, 3. No, just 2. Looks like just 2 documents. No, 3 documents. Yeah, a total of 3. Wait, well, let's take a look at this one here really quick. 4 documents. So I filed 4 documents, but they were free filings. So no, they weren't. One of those is a notice of appeal. So for the notice of appeal, I would have had to pay an additional $250 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. And my ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.